Hi, my name is John McLeod. I'm a lawyer at NON-PROBATE, and I work in the Charlotte office where I practice primarily in the areas of tax and estate planning. I'm pleased to be able to present to you a brief presentation on estate planning that I hope will help you become more familiar with this process. First, I'd like to thank the organizations that are responsible for putting this presentation on and inviting me to give this presentation. Those are Ag Carolina Farm Credit, Cape Fear Farm Credit, and Carolina Farm Credit. Thank you. I'd also like to say first that the information that I'm going to be providing in this presentation does not and is not intended to constitute legal advice. This information is just for general information purposes. If you would like to discuss your particular situation, you can engage our law firm to act as your attorneys, and I would be happy to speak with you. This presentation is going to provide a general overview of estate planning. Many of these topics are very complex, and it's not possible to go into the finer details of each topic. I hope that this presentation will allow you to become more familiar with some of the common estate planning terms and documents and concepts that you may encounter when you consider your own estate planning and meet with a lawyer to talk about your estate planning. This presentation, however, is not a substitute for taking the time to meet with a lawyer and discuss your own specific situation. Here's a list of the topics that I'll be talking about during this presentation: the reasons for estate planning, intestacy, types of estate planning documents, non-probate transfers, probate and estate administration, wealth transfer taxes, basis planning, and business or farm succession planning. The reasons for estate planning. Primarily, one reason is that you want to be able to be in control of the disposition of your property at death. That means avoiding intestacy, which is what happens when you don't have a will. Estate planning also involves planning for your incapacity during your lifetime. Tax planning is also a major portion of estate planning for many people, although it's not necessarily as big a part of estate planning today as it was in the past, given the high exemption for estate taxes and the fact that fewer and fewer people are now subject to the estate tax. Estate planning is also important to provide a smooth transition of a closely held business to the next generation. It's also very important to avoid family arguments and disputes. If you lay out a good plan, that can really help and prevent problems from coming up down the road after your death. As I mentioned, intestacy is what happens when a person dies without a will. That person is said to have died intestate. In that case, the laws of intestacy control the disposition of that person's property. Essentially, the state legislature has written your will for you. However, you may not be satisfied with what that will says. Here's an example of the intestacy laws of North Carolina. As you can see, the intestacy laws depend on your marital status, how many children you have, and whether or not you have any living parents. With regard to real estate, a married person with one child who passes away, half of their estate would go to the spouse, half to the child. If that person has two or more children, then a third would go to the spouse, and 2/3 would go in equal shares to the children. If that person had no children, but at least one living parent, then half would go to the spouse and half to the parents. If the decedent was married, but had no children and no living parents, then in that case, 100% would go to the spouse. Now, these examples, as I mentioned in the bottom of the slide, assume that there are no deceased children who have living lineal descendants, that is, grandchildren of the decedent. This is only for real estate titled solely in the decedent's name and would not apply to real estate that is held jointly with right of survivorship or as tenants by the entirety. Personal property passes in a similar manner, although in that case, the surviving spouse gets the first $60,000, or either, in the case of a decedent with no children, the first $100,000 before the remainder of the property is divided according to the laws of intestacy. Now I'm going to be speaking about estate planning documents. And the first document is the most fundamental estate planning document. That is the last will and testament. Your last will and testament should address the following issues: the disposition of your probate estate, the appointment of an executor for your estate, and nominate any individuals to serve as guardians for minor children. The next document that I'd like to talk about is a revocable trust, also known as a revocable living trust. The primary purpose of a revocable trust is to avoid probate administration. Property that is held in your revocable trust does not pass through your probate estate, and during your lifetime, you will typically serve as trustee of your revocable trust, and there's very little difference between the property held in the trust and property held in your own name. The revocable trust is typically used with a pour-over will that simply directs the executor to distribute any property in your probate estate to your revocable trust. Ideally, you would want to fund your revocable trust during your lifetime, and by that I mean title assets in your revocable trust, so that upon your death there's not a lot left in your probate estate, and there's very little property to be poured over into your trust from your will. Sometimes revocable trusts are described as a will substitute, because that's really, when you have a revocable trust, that's where the action is really happening. That's the document that is describing how your property is going to be divided up and distributed upon your death. Both wills and revocable trusts can create other trusts that will come into existence at some point in your future, commonly upon your death. Leaving property in trust is an alternative to just leaving it outright to a beneficiary. And this is commonly used in the case of gifts or testamentary gifts to a surviving spouse, minor children, or young adults that the testator may feel are not old enough and financially responsible enough to handle their own money, and they would prefer to leave that property inside a trust where the trustee can manage the funds. The trust can terminate at some future date or hold property in trust for the beneficiary's lifetime. In the case of minor children and young adults, it's very common to see a trust set up that would leave property in trust for the children's benefit until they reach a certain age, such as 25 or 30 or 35. Frequently, you see trusts that distribute out a portion of the property at each age like that as the child gets older. Now, why would you leave property in trust rather than just giving it outright to a beneficiary? I touched on that a moment ago. The first reason would be that the beneficiary is not financially responsible. That could be because they're a spendthrift, and anytime they have money, they go out and spend it. A dollar just burns a hole in their pocket. It also could be that maybe they're not a spendthrift, but they're just not financially savvy, and they're not experienced with managing investments, and they need help. In that case, it can be beneficial to leave the property to a trustee who will handle the investment and the management of the funds and distribute property to the beneficiary as needed. Trusts are also useful to direct the future disposition of trust property. For instance, you may leave a trust for the benefit of your surviving spouse that would benefit them during his or her lifetime, and then upon your spouse's death, the property would be distributed to your children. This is especially common in second marriage scenarios where the testator wants to support their spouse, but is concerned of leaving the property outright because maybe the spouse has children from a prior marriage and the testator has children from a relationship other than the current spouse, and the testator wants to make sure that something is left to his or her children after the surviving spouse's death. Trust also can provide an element of creditor protection for the beneficiary because the property is not held in the beneficiary's name, it's held in the name of the trustee. The next document I'd like to talk to you about is a general durable power of attorney. Sometimes these are called financial powers of attorney because the agent typically uses this document to help you manage your finances. It's not a healthcare power of attorney, which is what we'll be talking about in just a moment. But in a general durable power of attorney, the person who signs that document is the principal, and the principal gives another person known as the agent or attorney in fact the power to act on the principal's behalf. Attorney in fact was the term that was used for a long time, and the more recent trend and the term that's used in the North Carolina Power of Attorney Act is agent. As I mentioned, it's called a general durable power of attorney. It's called general because the powers granted to the agent are very broad and encompass a wide range of actions that the agent may perform on the principal's behalf. It's also durable because the agent's authority continues after the principal's incapacity. And that's really the most important time to have the power of attorney in place, when the principal becomes incapacitated. General durable powers of attorney can be effective either immediately upon execution of the document, or they can become effective upon the principal's incapacity. And these are known as springing powers of attorney. Not all states allow springing powers of attorney, but North Carolina does. However, most lawyers recommend to have your power of attorney be effective immediately upon execution of the document. That just avoids extra trouble that the agent would have to go through down the road to possibly find someone to declare the principal incapacitated. And it may make things a lot easier. Most lawyers prefer to have and recommend that the principal have the power of attorney effective immediately upon execution. The next document I'd like to talk to you about is a healthcare power of attorney, which is similar to a general durable, only it deals with the principal's healthcare. So in this case, the principal appoints a healthcare agent to make healthcare decisions on their behalf when they're incapacitated and they cannot communicate to the doctors and the healthcare providers. Generally, the healthcare power of attorney grants broad authority to the agent to make healthcare decisions. However, the principal can limit the scope of that authority and provide specific instructions to the agent. Living wills are commonly associated with healthcare powers. Other term for a living will is an advance directive for a natural death. These documents deal with end-of-life decisions and whether to withdraw life-prolonging treatment. North Carolina's statutory form provides 3 scenarios when the advance directive may apply, and you can select all or any one of these. The first is an incurable or irreversible condition that will result in death in a relatively short period of time. Next is an unconscious, or if the healthcare providers determine to a high degree of medical certainty that you will never regain consciousness. And finally, in the case of advanced dementia or another condition which results in substantial loss of cognitive ability, and the healthcare provider determines to a high degree of medical certainty that this loss is not reversible. A HIPAA authorization is another document that can be helpful to have in place. This document allows healthcare providers to share and release your private medical information with individuals you name in the release. Not all property that you have passes through your probate estate. So your will doesn't control the disposition of all of your property, only certain property. And non-probate transfers, they generally pass according to a beneficiary designation or to a joint owner as a matter of law. This next slide shows some examples of non-probate transfers. Many of these are very common, I'm sure you're familiar with. Life insurance and retirement accounts, for example, use beneficiary designations. And it's very important for you to understand who you have named as your beneficiary. I think sometimes people forget about that and think maybe their will take care of that, but that's not the case. You need to make sure that you know who your beneficiaries are on your life insurance policies and your retirement accounts. If you don't have a beneficiary name, then in that case, it would go to your estate and go through probate. Also, joint bank and brokerage accounts generally will pass to the owner unless it's provided otherwise, the co-owner on the account. Also, payable on death bank accounts. These are regular bank accounts where the owner designates a beneficiary who the bank account is to be paid out to upon their death. Transfer on death brokerage accounts are very similar. They just deal with stocks and securities rather than cash that's in the bank account. Also, real estate, which can be held as joint tenants with right of survivorship, where when one joint tenant dies, the other joint tenant automatically is the owner of that property. Or tenants by the entirety, which is very similar, except it is only available to married couples, and there are some legal aspects that make it slightly different from joint tenants with right of survivorship, but in terms of what happens at death and property vesting in the other owner, it's similar in that respect. And I should mention that in North Carolina, real estate, even real estate that's titled solely in the decedent's name, is technically non-probate because the title vests in the heir or the devotee immediately upon the owner's death. But in the case of property that's held solely in the decedent's name, the decedent's will does control the disposition of this property, unlike real estate that is joint with right of survivorship or held as a tenancy by the entirety. I've mentioned probate a couple times in the state administration, and that's not what this presentation is really about, but I did want to give you just a general overview of what that process involves. I know many of you probably are familiar with it, maybe from helping someone in your family with the probate or estate administration process, and you hear a lot about it, and you hear a lot of maybe people complaining about it or making a really big deal about how important it is to avoid probate. Some of that is probably a little overdone. It's not the horrific process that I think sometimes it's made out to be, but if you can avoid it, it's probably it's a good idea to invest that time to make plans to do that. But generally, what the process involves is submitting the decedent's will to the probate court, or in North Carolina, the clerk of court serves as that function. Applying for letters testamentary, where you're appointed to be the executor if you're named as executor in the will. Filing a preliminary inventory where you report the decedent's property. Identifying and collecting all of the decedent's property. Notifying creditors. Paying the decedent's debts and taxes. Filing an inventory with the decedent's property. Filing annual accountings if you're not able to complete the probate within a year, or a final accounting if you are, and distributing the property according to the terms of the decedent's will. Generally, this can take anywhere from a few months to a year. However, in some cases, it can go on longer than that. Obviously, in the case of a contested probate administration, it can extend the time quite a bit if there's a will contest or something of that nature. The next topic, broad topic I'd like to talk about is wealth transfer taxes. And historically, this has been a very important part of estate planning, particularly when the estate tax exemption was much lower than it is today. And I'll show you a slide in just a moment that shows how the estate tax exemption has gone up quite a bit over the last 20 years. And even in the last few years, it's gone up quite a bit. There's really three taxes that I would consider, generally are considered wealth transfer taxes. Those are the estate tax, the gift tax, and the generation skipping transfer tax. And I'm going to be talking about all three of those. And those are federal taxes. North Carolina no longer has any wealth transfer taxes. They've all been done away with in the state of North Carolina. However, some other states still do have their own estate tax or other wealth transfer taxes. One important topic that comes up when you're talking about wealth transfer taxes and estate and gift taxes is the lifetime exemption or exclusion amount. This is a combined amount for both estate and gift. So you have this lifetime exclusion, and in the year 2020, it's $11.58 million per person. And you can use that exclusion for lifetime gifts, or you can, if you don't, whatever you do not use during your lifetime, it's applied at your estate to cover any testamentary gifts that you make. This is in addition to the annual gift tax exclusion of $15,000 per donee or recipient. So I think a lot of people are familiar with that concept that you can give $15,000 to any number of people you want to in any given year, of a present interest gift, rather as opposed to a future gift. And that does not count against your lifetime exclusion for gift and estate taxes. There are also other types of gifts that you can make that don't count against your lifetime exclusion. These include tuition paid directly to education institutions. So you can pay your kids or your grandkids tuition, and that doesn't count against your lifetime exclusion if you pay it directly to the school. Also, medical expenses that are paid directly to a healthcare provider, as well as gifts between spouses. The estate tax is a tax on your gross estate after certain deductions and credits. Deductions are allowed for administration expenses, property passing to a surviving spouse or a qualifying trust that benefits the surviving spouse, and property that you leave to charities. As I mentioned, the estate tax exemption is $11.58 million for the current year. However, it's set to be reduced to roughly half of that in the year 2026, when the Tax Cuts and Jobs Act was passed a few years ago. They did not have the votes in the Senate to make it a permanent exemption of it's really $10 million indexed for inflation since 2010, which in the current year comes out to be 11.58, but they did not have the votes to make it permanent, so it could only be extended through the year 2025. That's why it's going to automatically go down unless further legislation is introduced and signed into law. And the current estate tax rate, once you use up your exemption, it works out to be 40% on property that is over your exemption. There's a concept that was it came into law back several years ago now. It's called the deceased spouse's unused exemption. And so basically, you have this lifetime exemption, uh, and whatever you don't use, you can pass on to your spouse. So, for example, if you die in the year 2020, you leave everything to your spouse, so you get a full marital deduction. You haven't used any of your exemption. You're going to have $11.58 million of unused exemption, assuming that you didn't make any lifetime taxable gifts. And you can pass that on to your spouse, and then he or she can combine that with their lifetime exclusion. And the concept of transferring the unused exemption from the deceased spouse to the surviving spouse is referred to as portability. And that's what you'll hear lawyers say about electing portability on an estate tax return. That's how you actually transfer the unused exemption, is by filing an estate tax return for a decedent. Even if there's no tax due, it shows the unused exemption amount, and that unused exemption is transferred and made available to the surviving spouse for their gift and estate tax purposes. This is the chart that I mentioned with showing the growth in the estate tax exemption over the years. You can see as you go back to the year 2000, the exemption was only $675,000. Obviously, it's grown quite a bit over the years to its current rate of 11.58 million. And as I mentioned just a little while ago, in 2026, it will go back down to that $5 million indexed for inflation since 2010. So it's going to be cut roughly in half unless Congress passes new legislation to extend it. There are a couple of Internal Revenue Code sections that may be helpful for a farmer or closely held business owner. The first one is 2032A, which deals with the valuation of certain farm and real property. Generally, when a decedent dies, property is valued at its highest and best use. But in certain circumstances under this section, real property can be based on its qualified use. So if it's farm property and it's used as farm property, then in assuming there are some other requirements that have to be met, but in that case, the property may be valued at a rate that's really lower than what it actually maybe could be sold for if it were someone might be interested in it for some other development purposes. The decrease in the valuation, though, is limited, and in 2020, that limitation is 1.18 million. The other section that could be beneficial to farmers or any closely held business owner is an extension of time for making the estate tax payments and a deferral to make those payments if you have a closely held business that makes up more than 35% of the decedent's gross estate. There are a lot of other requirements, and this is just a very general overview and mention of these two code sections, but 61 and 66 does allow the deferment for up to 5 years, and then you can start making payments each year for 10 years after that. And there are, of course, you are paying interest that whole time during the deferral and while you're making the annual payments as well. The gift tax, as I mentioned, it uses the same lifetime exemption as the estate tax. That's why sometimes it's referred to as a unified credit. The credit against the gift tax and the estate tax is one credit, so it's unified, as they say. 40% tax rate, just like estate taxes. And as I mentioned earlier, you do have unlimited deductions for certain types of gifts between spouses, tuition payments that are made directly to a school, and payments for medical care that are paid directly to a healthcare provider. You also have that annual exclusion. It's currently $15,000 per recipient. Now, I mentioned a couple of times about the estate tax exemption a few years ago, going up from essentially almost doubling from a little over 5 million to over 10, where it stands now at 11.58, and how it's set to go back down to roughly half of its current amount in the year 2026. And a lot of questions were raised about that with due to the way that estate taxes are computed by adding back in lifetime gifts on the estate tax return, and how that would affect individuals who made gifts in excess of maybe what the exemption amount may be at the time of their death, but under what the exemption amount was when they made the gift. And there was a question of whether those gifts that exceeded the future exemption amount but were within that current or exemption amount would be clawed back into the estate. And the IRS issued regulations explaining that there would be no clawback, and that a gift that would have been tax-free at that time will not be brought back into the estate to cause tax at a later time upon the decedent's death. Finally, the last wealth transfer tax is one that you don't hear nearly as much about, and that's the generation skipping transfer tax, or GST tax. This is a separate tax, and it applies, it's separate from the estate and gift. It applies when you make a generation skipping transfer, such as making a gift to your grandchildren, or a transfer in trust that will benefit your grandchild or a more remote descendant. You have an exclusion amount for the GST tax that is equal to the estate tax exemption amount, but they're separate. It's not unified like the estate and gift. You actually have two separate exemption amounts that you have to keep up with. And the estate tax rate is equal to the GST tax rate. Again, that's 40% once you use up all of your exemption. The GST tax, it doesn't apply to transfers that are not subject to gift taxes in the case of annual exclusions or the tuition payments and medical healthcare payments that I've mentioned a few times. Basis planning is something that's been talked about a lot more recently than in the past in the area of estate planning, because of the fact that the estate tax exemption is so high and fewer people are worried about that. And basis planning is something that is more applicable to a lot of folks these days. A taxpayer's income tax basis in property, which I'm sure most of you are familiar with, is used to determine the amount of gain realized when the taxpayer sells that property. And that is how you determine how much tax is going to be owed. A lot of folks are familiar with the idea of a step up in basis at death. That's what you hear a lot. You hear about when someone dies, the property that they own gets a stepped up basis. That's not exactly always correct. Well, the way it works is that the property gets an adjusted basis to the value as of its date of death, the taxpayer's date of death, which generally means it's getting a stepped up basis, because most assets tend to increase in value over time. But of course, that's not always the case. Some assets obviously go down in value, and in that case, it could be a step down in basis rather than a step up in basis. One issue that's come up in the area of basis planning relates to the creation of these estate plans that have been done for a long time that utilize a bypass or a credit shelter trust. Excuse me. Now, many attorneys created these plans for couples that use a bypass or credit shelter trust that comes into existence upon the first spouse's death. And that was done. One of the reasons it was done was because there was a time when there was no portability of the unused exemption, and it allowed both spouses to use their estate tax exemption amount. And these bypass or credit shelter trusts, it's known as a bypass trust because it's not included in the surviving spouse's estate, and a credit shelter trust because it allows both spouses or the first spouse to fully utilize its unified credit amount rather than having it wasted back before you had a portability of an unused exemption. And these trusts are typically structured so that the surviving spouse can access the trust property, but the property won't be included in the spouse's estate at his or her death. And this is generally beneficial if the property would have caused the surviving spouse to have an estate tax issue and have an estate so large that it would be subject to estate taxes. So it would be good to keep that property out. The downside, of course, is that if it's not included in the spouse's estate, then you don't get that second step of it in basis. You only get it at the death of the first spouse. The property is not included in the surviving spouse's estate at his or her death, so there's no adjustment at that time. So if including the property that's in this trust in the surviving spouse's estate would not cause the surviving spouse to have a taxable estate because the exemption would cover the surviving spouse's estate without any type of estate tax being due. Keeping the property out of the surviving spouse's estate is really not beneficial in that case because you likely miss out on the what would be, or you would miss out on what is likely a step up in basis, assuming the property is increased in value. Now, there are several different techniques that can be used to bring that property back into the surviving spouse's estate so that you can get that step up in basis. So if you have an old plan that has been around a while, if it's that you had done years ago, and maybe the first spouse has passed away and there was this trust created for the surviving spouse, if the surviving spouse is not going to have a taxable estate, it may be worth talking to a lawyer about what could possibly be done to bring that property back into the surviving spouse's estate so that you could get that step up in basis. Of course, the risk is that the estate tax exemption is obviously it's set to go down in 2026, but it could be changed at any time before then with a new Congress, possibly a new president, and you just can't really predict exactly what will happen when it comes to the estate tax exemption. It could go up, it could go down. You just can't really predict what Congress will do. The last topic that I'd like to talk to you about is business and farm succession planning. And this is about putting in place a plan to transition the ownership and control of a business or a farm to the next generation. And one of the challenges that you frequently see in family businesses is that some children are going to be actively involved and be the natural successors, and other children are not going to be involved. Maybe they're not interested in the family business for whatever reason. They want to do their own thing, which is certainly fine. But if the business makes up a large part of the decedent's estate, they've got this issue where they want to see the business continue, and they would like to leave it to the child who's actively involved in the business. However, they may not have enough other assets outside of the closely held business or the farm to make equal distributions to the other children, and they'd like to treat their children equally. So that creates an issue that has to be dealt with. Now, possible solutions to that is one would be simply just rewarding the children who are actively involved in the business with the larger share of the estate. That, people probably have a lot of different feelings about that. Some may think that the child has been involved in the business, maybe they've been responsible for growth in the business and they should be rewarded. But oftentimes I find that people really like to treat their children equally. And in addition to that, anytime you're not treating your children equally, that could definitely cause some problems down the road and family friction. One other solution would be to recapitalize the business into not voting and non-voting interest and leave the voting shares to a child who's active in the business. That way they have control, and the children are out who are not involved in the business. They can't control the business, but they're still getting the benefit maybe of the ownership and the economic interest in the business. Another option is to incorporate a buy-sell agreement, and this can be done certainly in conjunction with the voting and non-voting shares. And you really need a buy-sell agreement if you're in a situation like this where you have a small, closely held business and one child or one or more children who are involved in the business, and other children who are not involved in the business. And that will allow a situation where you can leave things equally to the children who are involved and the children who are not involved, but give the child who is involved the right under this buy-sell agreement to purchase the shares from the child or children who are not involved, and also give the children who are not involved the right to sell their interest to the children who are. So everybody gets economically treated the same, and the child who is involved in the business has assurance that he or she will be able to be in control. So that's all I have. I know this was a quick and very broad and general overview of estate planning. I hope that maybe it was beneficial to you to hear about some terms and concepts that maybe you've heard about, maybe you haven't, but hopefully you learned a little something. If you have any more questions, I'd be happy to talk with you about it and happy to speak with you about your estate planning. Here's my contact information, and thank you very much.